Hi, everyone. Welcome to episode 120 of the Immigration Lawyers Podcast. Thanks again for tuning in. Before we start, I wanted to get 2 points out. One is I did a YouTube video that analyzes the 5-year rescission statute, INA 246, where they say, you've probably heard this before, that if you have a green card for 5 years and it was issued incorrectly, you get to keep it and they can't come after you. Why I go into the truth of that and I break down the rules. So definitely, if you go to the Immigration Lawyers Toolbox website, the website too somewhere, but on the YouTube page and on the LinkedIn page, that video will be there. YouTube's probably the easiest place to find it, but it talks about 5-year rescission. Definitely check it out. It's something you have to know as a practitioner. And secondly, today I'm going to do an agency review and updates of court cases, agency stuff that's happening. Now, I made this list, and it's getting longer and longer. I made it like weeks ago, maybe a month and a half ago, and I haven't had time to do it, so things getting piled on with regards to changes. And so some of the stuff may seem like it's like, well, that happened a month ago, but I got to talk about it just to keep all the information in there. And then there's stuff that's like this morning we had a bunch of last couple of days we've had memos on naturalization changing stuff. I didn't include that here. I'll include it in the next one. But I just want to give you a heads up. It's just a lot of information that's happening, and I want you to hear it because one thing I get from a lot of people contacting me about the show and thanking me is that it helps them keep on top of stuff because you're so busy in your day-to-day, just the grind of doing the cases you're handling. It's hard to keep up on all the changes that are happening. So I want to at least mention certain things so they're in your head, so you have them as a reference point. So if something pops up, you'll remember, oh yeah, this, John talked about something, so I should look into that and see what that was. And hopefully that's going to be one of the goals of these agency and court updates podcasts that I do. I'm probably going to have some interviews coming up, and I'm going to go back to history stuff. I don't know how much you guys are enjoying it. It looks like it's a good crowd listening to those, but I enjoy doing the history research and learning about it. It's fascinating, and it just helps me be a better immigration attorney, so I definitely want to share that all with you. So with that, let's get it started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted, and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Okay, so we had a big change in the structure of the immigration system, employees and stuff. The acting USCIS director is now the deputy secretary of DHS. What's his name? Cuccinelli. And now we have a new guy named Wolf at the head of DHS, and we'll see how that plays out. They say he was a lobbyist for like H-1B companies or something like that, so he might have somewhat of a different perspective on these things. But if he got past Stephen Miller for that, his review, probably you could expect the worst. Just looking at DHS right now, DHS has, I think, the Coast Guard in it, and it has the humongous USCIS in it, FEMA in it. It was this construct that they made after 9/11, thinking that if we have all this stuff under one house, it's going to be more effective. But when you create something that's that big and that unwieldy, that many people, I don't think they could be done efficiently. It probably should be broken up into something that makes more sense. But who knows? Government agencies are known to be efficient, so that's probably not going to happen. Next thing I want to talk about, and this is under USCIS stuff, I'm breaking it down based on the agencies, was a case called Burden v. U.S. Department of Homeland Security in the Ninth Circuit 2019. This was a Adam Walsh case, and they had appealed it. And what the court found was with these kind of decisions on Adam Walsh cases that USCIS does are not reviewable by appeal. It's really a decision that USCIS will have to make. So just a heads up, if you're doing Adam Walsh cases and it's denied, the appeal option doesn't really exist, at least in the 11th Circuit, but I think the other circuits probably find the same. So essentially, 11th Circuit is saying the court lacks jurisdiction to review the process or the outcome of the no-risk decision under Adam Walsh. So jump into the business immigration side of things. We're seeing is that on RFEs, on O1s, and we're getting pushback saying that the wage doesn't meet the wage requirement, as if it's some sort of perm thing where you do prevailing wage. And also, when I first wrote these notes, I said it's coming to L1 soon from what I'm hearing, but I had a colleague send me an RFE where they said in the L1, the CEO wasn't making what the Department of Labor, blah, 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 says they should be making, which is This is really dumb because there is no prevailing wage requirement for an L1. You just got to be more than the minimum wage. And these people were getting paid well in that L1 case too. So in O1 is hard because, their jobs aren't consistent. You might have they're coming here to do various events and they might not win one. They may win one. They'll be offered 2 months training for it. So it's not like they have a day-to-day 9-to-5 job. So these grids they put people in these jobs, as fixed boxes of how this should be, is so frustrating. Being an O1 attorney right now is hell. And being an L1 attorney myself, I could tell you it's hell. It's so annoying that they're putting people through this. Another interesting case that came out in regards to a family case is the Ninth Circuit held that an I-864 defendant cannot avoid liability by claiming marriage fraud. So they can't say the marriage was fraud, so I'm not liable for the affidavit of support form I-864 sponsorship. That was interesting. They failed on that argument. Okay, and another one, it says Silicon Valley woman to pay $50 million for allegedly misappropriating $45 million from green card holders. These are EB-5 people. They had the money go into their personal possession, and that's how it was stolen. And it's an interesting thing seeing this kind of stuff. I'm not even sure if that woman was a lawyer, but the names are Chinese here. China is the big EB-5 place, and I have Chinese clients who do EB-5 and have gotten their green cards, and they come to me for sometimes for citizenship or something like that after years. And I ask well, who was the lawyer that did it? And so many times they say, I don't know, it's just an agent. He did all this stuff. They're investing all this money in really huge amounts of money, and they're risking their lives and their future and all this kind of stuff. I know they're not really risking their lives, but they're risking their future and a bunch of money. And it seems like a lot of these investors don't bother, seeing who the lawyer is or even having a lawyer handle the case. Like one of the cases I was doing ads for, the agent hadn't told them that the children could get green cards too. So the guy was coming to me to Nats because he said that I want to naturalize so I could file for my children's green cards. But I said, first of all, you could file for your minor children or even adult children. They're single as a green card holder. And secondly, why don't your children have green cards already? And he's like, well, no one told me they could. So I've had a green card, keep going back and forth. I'm like, oh, that's just crazy. No, there's no lawyer to tell you that. I mean, it's even an upsell if you're, it's not upsell, it's with the family. I guess you could add that on as an application part. But this is it's insane in the EB-5 field. You think these are more sophisticated investors and they would think it through more, but it's not the case. They make these decisions without really thinking it through and getting good guidance. And that's where a lot of the fraud, we see a lot of money get stolen, is because of this. I mean, why would they put the money in that one person's account? I mean, couldn't they do a little research, ask a second person, get another opinion about how the EB-5 money transfer system works and the trust accounts and everything? So the fee increases are probably coming. I had done an analysis and I posted on this online in a lot of groups. So there's lawsuits, obviously, probably going to put a hold on this somewhat. But the administration is going to be increasing fees because they say, it should be. But what's annoying is there's probably going to be a lawsuit about this. A portion of that money that's USCI's filing fees for our cases is going to be going to ICE. So that's ridiculous. But they make some notes in that long write-up. They had the information all about the fee increases are going to be. And they didn't have exact dates on when they're actually going to go into effect, but it's probably going to happen next 30 or 60 days. They said in fiscal year 2016, USCI has collected a total of $416,000 from the $30 return check fee. So this is when you send a check and it bounces, and they charge a $30 fee to people because to make up the bounce check. It was $416,000 that they got from it. However, it cost them, and the financial service provider billed them $508,000. So they're getting rid of the $30 fee that you have to pay if your check bounces, because it costs them more money to collect on that fee. So that didn't make any sense. But that was an interesting thing I read in there. What's really annoying is that what we're accustomed to nowadays of filing the I-765 EAD and the I-131 AP advanced parole, those are going to begin to have separate filing fees. So if you file concurrently, it isn't that where you could write those off. So now when we're talking, after this goes through and we're talking to clients about their decision, before I would just always include advanced parole employment authorization. Now I have to ask if you think you need one to make it worth filing. Now nowadays it's pretty much not worth even filing them because it takes so long to get them. Most of the time my clients get their green cards beforehand, or their interview is a week after getting the EAD combo card. But, if they're going to charge, that theoretically means that less people are going to do it. And if less people are filing for those, probably the processing times will get less, maybe. In a logical world, that makes sense, but I don't know if in immigration world that's going to happen. Another thing is that, as you know how we always have to, the way they break down the fees for application as biometrics is they write what the fee cost is and then the add-on for the biometrics, which is very misleading. And I'm sure a lot of people doing a pro se probably send the wrong check amount. But they're just going to get rid of having a separate biometrics fee and have it included in a one lump sum fee, which just for practicality, I think it makes a lot more sense. Now the I-129 fee is going to go up, and it really depends on which type of application you're submitting. So that's going to be annoying. So depending on AHL or whatever I-129 you're doing, there's going to be a different fee, which is going to lead to a bunch of wrong fee filings. Now the I-907 had a slight increase already. I think it was like $25, but there's no increase set in this this rule proposal that they had released. But an interesting thing and an annoying thing they're going to do is they want to change the 15-day response requirement. So when you do premium processing, they have 15 days to respond. Instead of doing it 15 numerical days forward, calendar days, they're going to change it to 15 business days. So essentially, it maybe becomes 20 calendar days. So that's a fun thing that they're doing there. Now, one of the main parts where it's going really bad is application for naturalization from N400, going from $640 to $1170, maybe $640, maybe plus the biometrics, maybe more. So that's a huge increase, and they're trying to get rid of fee waivers on it too. Asylum is going to have a fee for the first time, $50 fee for I-589 filing. And just quick note, we're seeing this a lot of people who write NA even or none in the answers for the parts where you don't need to answer on an I-589 asylum application. If people are missing one box, or sometimes people are writing NA when they should write none, and those files are being returned. So that's a massive headache. And one thing that they're going to do is use the funding. They're going to use some of this funding to institute finally the entry-exit screening system. They were going to start taking photos of American citizens traveling back and forth in the airport, but there was pushback, so they canceled that. But they're probably going to start instituting this exit system that they've been talking about since 9/11. Now, the I-131A application for carry document, this was the thing that came instead of the that stamp that they put in your passport, if transportation letter. This I-131A, that's fee increasing a lot, going from $575 to $1,010. That's a lot. Then the L's and stuff I talked about. The application for suspension of deportation or cancellation removal, that's jumping up, and I have all these numbers here. What's going on? It's going to get more expensive, and as well as a bunch of other ones. The N336 is going to go from $700 to $1,755, so it's just messed up. To moving on, I saw an email from I could name the person, but apparently there's crackdown going on MAVNI cases, and this person said that at the N400 interview for these MAVNI cases, they're doing massive numbers of irrelevant questions, apparently trying to harass MAVNI people and wear them down, and so they have to do a sworn statement of all these random and detailed questions, trying to catch them in a lie about everything about their personal life and background, so they can say it's a mistake. So you got to be careful. It's under oath, and so one mistake could be a reason that the government gets you. Maybe refuse to sign it or get a supervisor and just be tough on it. But apparently it's probably an internal thing that they're doing, so we got to deal with that. And I don't do MAVNI cases, but and they're less and less because of the changes, but that does exist. And then USCIS put out this email that it was USCIS releases report arrest histories for illegal aliens who request DACA. So they pretty much are just, making DACA people look horrible, but based on arrests. And that's what's a little weird and what their games they're playing. Not convictions, but arrests. And there's could be mistaken arrests. There could be all sorts of issues with that. So by using statistics like that, it's kind of ridiculous. And the way they word them, so they said nearly 110,000 DACA requesters out of nearly 889. So 12% had an arrest record. So, okay, people get arrested for all sorts of stuff. But offenses in these arrests included assault, battery, rape, murder, and driving under the influence. But it's misleading because some basic arrests for maybe driving without a license may be included in this. So that's what was the shady thing going on. Now, there was a Latino Marine vet, and he was suing $1 million for wrongful imprisonment as a U.S. citizen. He was lawfully in prison. I think it was in Michigan. So he's suing on that. And that's the craziness. This guy, authorities released Ramos Gomez, who suffers from post-traumatic stress disorder, when he was able to prove his American citizenship. So the idea that you have to prove your American citizenship, they can't just look up your social security number and find that out, it's very, very scary kind of situation. You get deprived of, your rights that easily. Now, speaking of losing your citizenship, there was this woman that was talking about her that had, joined ISIS. And, she wanted to come back, and she said she was apologizing. And the State Department revoked her passport, saying she wasn't a citizen. The judge agreed and said, yeah, this person was not a citizen, so she can't come back in. So that's the thing. These, citizenship could be revoked, could be given mistakenly at first. That's one of those things I always tell clients: get the form. What is it called? The N600 form, and which his fee is increasing I think it's decreasing actually on those. I think they said the N600 the N400 was being subsidized by N600 fees. So they're just going to increase N400s and decrease N600s. But it's so much better to have a DHS letter that says you're a U.S. citizen as opposed to having just State Department, because these kind of things could happen. I mean, these are extreme situations, but it could happen. Now, an interesting thing that happened is USCIS also issued another memo. This is crazy. Every day is a memo. Like, what's going on? And they said that if you have a conditional residency ISM-51 and it lapses or you get denied or whatever, your green card status automatically ends. But that then opens the door for you to adjust status on some other basis again if an appropriate status is available. Let's say you married a U.S. citizen, got a conditional green card, and didn't file I-751, so your green card automatically is denied. Before, sometimes you'd have to go from a judge for them to formally remove the green card, but now it just that lapse allows you to adjust again. You don't have to. That's a formal losing of the green card. I guess what happens is, let's say you're overseas and I-751 gets denied. All of a sudden, you officially lost your green card. How are you going to come back in? Those kind of cases, I would definitely refile the I-751 ASAP. Hopefully, USCIS gets it and you get a receipt, and then use that to try to get in, or just use the existing green card that's already expired, and try to get back to the U.S. Hopefully, the airline will allow you board with the letter or the receipt, and then at CBP, request parole for going to court, I guess, and that'd probably happen. So it's a weird situation. Now, moving on to Department of State. The new DS-260 added some questions, and I mean, they just added some questions overnight. Also, doing a form, there's more questions, but they're asking for all phone numbers and emails and disclosures of non-listed social media sites. So they have this thing where they ask specific social media websites, like what your handles are on those. But then they added another question that said, if there's any you want to reveal that have not been listed above, please let us know. So, I mean, really, who would want to go through an extra hassle? And I think they added a 5-year travel history. I don't think that was there. I think that was for DS-160s for non-immigrant visas, but they have a 5-year travel history there too. Now, the travel ban situation, I've been hearing a lot of talk about this. So apparently they created some sort of computer system that's got more efficient at handling these kind of things. So my travel ban cases, when it comes to immediate relative kind of cases, they're going through. We just go to interview and they give them the visas pretty quickly, sometimes like same day. And I had one case where it was a parent of a U.S. citizen, and the case had been pending for 3 years. It was even before travel ban came to place. They got administrative processing, then travel ban came, so they were stuck. So about 2 years and 8 months, all of a sudden I get an email, and the client did it. I just got the email. And usually the embassies don't talk to me. They always contact the client directly, which always annoyed me because the client has to give them the info, and they don't always do it. But they said, come here on this date and bring your passport. And so okay, client got up, got it, sent it. So that was interesting. And they're potentially going to file suit if it was going to go any longer. So it saved that hassle. So it seems like they're going back into the backlog and clearing stuff up. So hopefully those ones that are going even longer will finally get, some attention. But what is really messed up for these Iranian cases in particular, travel ban affected a lot of other countries, but in Iran, there was a designation that the IRGC, Islamic Republic Revolutionary Guard Corps, Sepah, SCPAH, it's like this paramilitary unit that's an attachment to the military. The U.S. designated them as a terrorist organization, and once that happened, then all these other people now are being found inadmissible under this category of supporting a terrorist group and stuff like that, 212A3 or some blah blah blah. And the messed up thing is, Iran has conscription, where it's mandatory military service. And there may have been people who, 15, 20 years ago were conscripts into this organization, and they went there and they did what they had to do. It's not like they did anything crazy necessarily. And so they got out, and all of a sudden they married a U.S. citizen coming here, and they're getting denied admission, being found inadmissible because of it. So, and there's nothing. It's so difficult to deal with that, and these are popping up in emails and seeing other people. It's just like a couple weeks now. This is constantly popping up. So that's a terrible thing that's happening to those kind of people. Now, one note a colleague was complaining about and talking about is when you do an L1 blanket, they usually list the actual employer that's being listed, but nowadays they're switching up where visas are being listed as the parent company that got the blanket visa, not the actual employer. So sometimes there'll be several layers of companies, and you want the actual employer to be listed on the L1 notice or the visa stamp so that people can say, I'm working for this company. But now they're doing the main parent company that got the L1 blanket. And so when some person is entering SCBP, they say, I work for this company, they'll look at the visa and say, well, it says another company, or your pay stub show another company. So that's the thing that's going on. You could argue with the embassy, maybe they could not do that, but I have this long write-up here about what we're supposed to do, but I'm not in the mood to read it. So just something to keep in mind. Now, one messed up thing that's happening is, I know they're redoing reciprocity chart times, in particular for Paris, for France. And like E2s are going down in time, how much an E2 could be for a French citizen. H's, so like F visas are going from, all these are going for 60 months. So F going to 25, H's are going to 20, L's are going to 17 months. So that's a 17 month L, what the hell? And R is going to 16 months. So it's a messed up situation. And as some other embassies too, they're re-reviewing the reciprocity charge for how long they give visa stamps. And it's going to be very disruptive to business because they either got to constantly go out and do new, get visas or extensions. So it makes the price of business go really high for these investors in foreign labor. Now, there was a meeting at the embassy in Paris as well. It was like one of these ELA, going to embassies kind of stuff. And they gave some notes on E's. So let's see. The full notes are forthcoming. They only book out a minimum of 3 weeks ahead of time for the interview on an E. Sometimes it'll be 4 weeks or more. The applications must be submitted electronically within 2 days of booking the appointment. So that's important. Or at least 3 weeks before the appointment, if the interview date is more than 3 weeks out, to give officers a chance to review the application before the interview. So I have some quick notes. I copy pasted them from there for my own notes. And the U.S. consulate in France made some important point to say, if you said that your passport was lost and then you find it, don't use it because that passport is not going to work anymore, and because it's been flagged. Now, there is this emergency passport, this 12-page document that you can get from DOS, but the country of France doesn't accept those emergency passports, so don't get those either. It's not going to help you. So that's a little interesting thing I thought I'd put in there. Now, there was a DOS liaison meeting October 3rd, 2019, and there was a bunch of questions that came, but some I wanted to discuss. So is it possible for an applicant who's completed DS-160 for one consular post and then applies for an immigrant visa from another one, do they still need a new DS-160? And they come back and they answer, well, it's technically possible to do that. Maybe the transfer might not happen, it might not work. So to avoid adverse issues, you should just complete a new DS-160 and submit that with a new barcode. So what happens if you get a new passport and it's not the one that you use to schedule the interview in the system? They say it's not necessary for the applicant to submit a new DS-160 that could be unlocked later by the consular and updated with the new passport info. But they should just bring the new and old passport to the interview. Now, one thing that happens is, it says, the question is, pursuant to 9 FAM 403.2-3981, an application for non-immigrant visa must be electronically signed by the applicant. In light of circumstances, blah, blah, this FAM area authorizes a third party, including a person with legitimate interest in the applicant, to electronically sign the application. Does this provision of the FAM permit applicants' attorney to electronically submit it? So it's saying if the applicant can't do it because they're illiterate or some other issues, can a lawyer do it? And they say yes. When an applicant's attorney reasonably may be determined a person having either legal custody or a legitimate interest in the applicant, they could do that. So it becomes important. Recently in Iran, there was this government crackdown where they shut down the internet for a week. And it's right at the time where, someone's embassy interview is happening, you have to log in and submit an updated DS-260, this and that. It's like they didn't have access to the internet, so what are you going to do? A lawyer has to do it. I try to avoid that kind of stuff, and they had a relative that could do it, but the relative just couldn't understand what to do. It's not that hard to go to DS260. The client already reviewed it and confirmed the info was good. But then when they came to press it, the done button, all of a sudden the internet shut down. And so those kind of issues come, and they said if there's a legitimate interest, it's fine. So that's important to know, because it's definitely the kind of stuff that pops up. But also they said since incomplete applications are stored by the system for 30 days only, it is also advisable that applicants save their applications to their own servers. I think I've had applications, I got to check, I have one, but I have them that last 30 days because clients are taking forever and we're not submitting them. So it says, download and save it, which I just, in case this is true, I need to do that because I don't feel like filling out that DS260 again. Sometimes you get a DS260 and it's so easy to fill out, so quick. And then you get one where it's like, it takes forever to do it, and the information, so many addresses, so many educational stuff, that you get timed out a million times when you're trying to put address history. It's so infuriating, especially with the new security systems that they put in, which just makes everything insecure. But okay, here's the question they asked about B1s. They said there's an absence of guidance on the correct non-immigrant visa category for a crew member of a private aircraft. Although it addresses private yachts and certain foreign airline employees, the FAM is silent to this point. The C or D1 visa categories are limited to commercial carriers. Visitors without a visa, commonly referred to as ESTA, are limited to passengers on signatory carriers. So it says, what kind of classification do they need? They say, yes, the B1 is a correct non-immigrant visa category for a crew member of a private aircraft. And we will take this recommendation to add a note on this FAM section advisement. So these weird situations pop up, especially nowadays with private jet travel increasing. So some facts: the U.S. let in 0 refugees last month. I think this was for October, for the first time since records began. And then USCIS is instituting measures to deter frivolous or fraudulent asylum seekers from obtaining work authorization. I think what they had said is if you came in unlawfully, you can't file an EAD. And so that was the fun stuff of going with DOS. I'm not sure why I put USCIS thing at the end of DOS, but it's so much. I had these notes on. I just tack them on. Sometimes it goes in the wrong area. So the next one is CBP. An interesting thing a listener told me about is at the border, they're seeing a spike in asylum claims for citizens of Cameroon. Now, Cameroon's a country in Africa and is having, I guess, upheaval there. And so they're finding their way into Mexico and then requesting asylum at the border. So that's a thing you wouldn't expect happening over there. Another CBP note that's happening, this going back to Iranian cases, is that even U.S. citizens that are entering are being taken to secondary. And the reports saying that they'll go into how many kids you have, what you do, where you work, what your parents do. They ask if you have a second passport. They go through a couple series of questions. They ask them all over again. They ask about addresses, phone numbers, contact info. These are U.S. citizens. Some people are saying it takes like 45 minutes of questioning. And so that's difficult. They also ask maybe social media handles and stuff like that. So it's a messed up thing. There's no security even if you're a U.S. citizen. These words don't mean anything anymore. These so-called rights and all that kind of stuff. Now, the ACLU had a major victory in Boston, the federal court there. Unfortunately, the injunction they placed, or the rule they placed, is only for, whatever the airport is called over there in Massachusetts, the international airport. But they found issue with the fact that they're doing these unauthorized searches on people's electronics, saying it's an unlawful search and seizure. So if you're entering at that port, they need to have individualized suspicion for contraband before doing these kind of searches. So that's an amazing victory, but unfortunately, it's limited to, it's not the tip of my tongue what the airport is, but the one in Boston O'Hare, maybe. And then CBP apparently is writing fake court dates on paperwork for the migrants in Mexico program for them to come back, so it's causing them to lose their place in line. So a messed up situation all around. So practice management stuff. I was reading this website, and apparently there was this thorough review of immigration or just attorney presence online, and it says nearly half of solo lawyers have no website, which is incredible. And then it says 2/3 of firms not on Twitter, 30% have blogs only. This is lawsitesblog.com. And then there's analysis by the American Bar org, AmericanBar.org, American Bar Association. It costs a bunch of money to get the actual info, so I didn't buy it. But it's interesting not having a website. I mean, a website is a business card. It's like not having a business card. I mean, I have business cards I don't carry anymore because I think the website is a true business card. So if someone asks me my business card, I get their phone and we say, look me up on Instagram, or here's my website, JK Law. Connect with me like that on LinkedIn. Because like if you get that piece of paper business card, it always goes in the trash. I've been collecting business cards when I go out for a decade now. And I'm the person who always reaches out to the people contacting me. Even though I got a bunch of information help I give people, it's always me reaching out. So I think business cards are worthless. And I get people that are older. Sometimes they look at me like I'm like a moron because I don't have business cards. Then I look at them like, no, you're, I said respectfully, you're the moron, because what you need is to have, a new way of doing things, which is the website. And I actually got a client who found me on Twitter. It was yesterday. Interesting case. But it's like that stuff works. And then census data shows a record 67.3 million people in the U.S. speak a foreign language at home, including more than half of people in 90 cities. So God bless. It's good to have multiple languages being spoken. It's good for the brain to have these people that are dual lingo. A lot of anti-immigrant people are going to take that the wrong way, but it's a show of strength. And it's powerful because that means America could always do trade with all these countries in a much better way. So imagine like a Chinese person wants to do trade in Russia. It's going to be hard because of the language barrier. But imagine a bunch of Russians knew Russian and Chinese. You know how much good business they could do there? So they will take this stuff in the wrong way. The power of America comes from the fact that we could do this kind of speak to other people. Okay, so I had a note here. Another thing I want to talk about. I did this. I have for the Immigration Lawyers Toolbox, I have a daily tip program that I do for subscribers. And one of the tips I just did a sneak peek on a release is that on a K3 visa, you don't need to pay an I-129F filing fee. So, a K3 is when you do an I-130 marriage case and you hopefully do a K3 to make it a little faster, which, I checked the stats for last month, 0 K3 visas issued. So it's not something to do, except for the fact that anecdotally it seems that if you do file the K3, the I-130 may get approved much faster, like in 2 or 3 months. It's happened. But it's just anecdotal, so I don't know. But if you are filing the K3, you don't have to pay a filing fee. There's no filing fee for it. So the I-129F is free on those. So unfortunately, the way it's written on the instructions is bad. But I was looking at websites for the lawyers, and they're saying, yeah, you got to pay a fee of $535, and I was like, dude, that's incorrect. And I saw it on all the first page results for Google on this, on the law firm. So I wanted to put that out there. I thought that was important enough to take it out of the premium model and give it out to the people for free. So one last thing. So the Immigration Lawyers Toolbox is an updating information system. It's kind of like this podcast, but more juicy information and market information that's going to help you make more money. Just like this situation. Don't file a K3 without money, but even better. And I talk exactly about the marketing things I'm doing right now that are successful, and I just tell it to members. And you can always just email me at info@immigrationlawyerstoolbox.com, and we can get information on that. But I also have the Champions for Freedom program, which is training in both hardcore, more marketing, and the way I've done it, where I'm running this successful solo practice and living the life here, my family, and doing well. It's having time to do podcasts and videos, all this kind of stuff. The only thing that's keeping me is for the kids and the baby screaming up all night and giving me a headache. I don't get headaches. And for I think probably the first or second time in my life, I got a headache today because I haven't slept in, let's see, the kid turned 2 months last week. So let's do math, 4, 8, 13 weeks not sleeping. It's like a human record, but it's still, everything's functioning perfectly when it comes to the business. I teach this stuff in the Champions for Freedom. The idea is you're buying your own freedom, and then you can help other people with their freedom. And it does training for immigration law itself. So because a lot of my listeners, how this started was a lot of my listeners are people that are in different practice areas, non-immigration attorneys, frankly, and they want to get involved in this and listening to this and learn. I just made it easy, years and years of reading. I spent all day, all night reading immigration. As you can tell from these podcasts, it's pretty much my hobby, my life other than my family is just thinking about immigration law. I wouldn't say I'm an advocate necessarily going out on the streets and protesting prisons, immigration prisons and that, but I think I'm still an advocate for other immigration attorneys. That's what I like to advocate for. So I try to get all this information, distill it, put it out there. If you follow my LinkedIn page and YouTube page, you'll see all this information is coming out to make you a better practitioner. But the real hardcore kind of stuff, I'm saving it for the program. And for people who really want to take next level, and so those are there, and you can always reach out and contact me at info@immigrationlawyerstoolbox to learn more about these different programs I'm starting. I'm going to have one that just breaks down the idea of podcasting, because I get clients from podcasting from all different ways, and how I do that. I'm going to create a quick program for that. So if you're interested in that, and the programs are different pricing. There's like a low price, medium price. The hardcore Champions for Freedom program is a really expensive course. It's a premium course. I'm teaching you how to make a 6-figure salary for the rest of your life every year. So that's that. But like the podcast program, I think I'm going to do that. It's just an easy, quick thing because I really think it's important that you dedicate yourself and do a podcast. It's a fantastic way for you to build an audience. I've had success. I got a professor job from that. I was quoted in the New York Times from that. Consistently get clients. My association with top lawyers, brings my standing up. When I first started it, I get so much information, connections. People contact me, telling me stuff, mentor. It's just unlimited. And so it's not just creating another immigration podcast because it seems like we're getting inundated with those, but it could be whatever you want. It could be a podcast about, cooking if you like cooking. And it just mentioned, I'm an immigration attorney. And all the people are down with cooking. They'll remember that the host of this program, although in their hobby time they're making this podcast, they talk about cooking. But in actuality, at their day job, they're an immigration lawyer. So if something pops up, they'll say, oh yeah, cooking with Bob. Oh, Bob was an immigration attorney. Let me send him clients. It's that easy. I mean, easy as you got to have dedication to do something continuously for years at a time. But the payoff is real. I mean, it's real. So I'm gonna do that to do it because it's overwhelming. Like even now, like I'm like, there's probably information out there for people to do podcasts, and I looked up online. There's how-tos and stuff. But I was reading this stuff and I got confused what they're saying. And I remember when I first started doing it took me a year to figure it out. And once I figured out what to do, I'm like, oh, this could have been told to me much quicker and I could have jumped on this and not waited an extra year to get a podcast out. And so I want to really get that out. If you're interested in that and talking about it and setting it up, I'm going to be recording that and creating that program. Just email me at info@immigrationlawyerstoolbox.com and I'll send you more info. I think it's something that you should do. It's a lot of fun, and it gets you connections in the world, and it leads to a lot of great things, which has happened to me. Okay, so the next agency is ICE. Federal immigration agents in New York City were permitted to use a powerful surveillance device called a stingray that spies on cell phones to track down an undocumented immigrant, according to court documents. What was the crime? Illegally re-entering the United States after being deported. So this is like a really dangerous thing. The intense internal spying that's happening with ICE. And so, they use it under the guise of immigration stuff. And illegally re-entering, is that a crime worthy of because people get swooped up in this stingray kind of stuff. But the larger picture, and this is for people that are citizens, not immigration lawyers who don't even care about immigrants, is this technology is going to come and bite you in the ass. Be wary. This stuff is just being tested on the immigrants, this is an extreme example, but in Nazi Germany, they first tested it on people who were felons or who were other undesirables before they took it out on the regular population. So we got to be very careful on using things that prohibit and take away our God-given rights in this country. And so that's something that's really important. One note I wanted to mention, there's a thing called Interpol Red Notices. And this is a notice that countries give to Interpol, which Interpol is essentially a centralized location that gets a bunch of data on criminal history and this and that. And it goes out there, then they give it out to local law enforcement to say like there's a war. But it's like the countries can make this stuff up, especially if it's political. Or you might have someone that gets an in absentia criminal order because they didn't even know about it show up. And all of a sudden they have a red notice. And this could really affect our clients because they might not even know. So imagine you have a person here on a student visa. They get some sort of red notice because they failed to appear for some sort of hearing that they never got notice for. And they go to adjust status and they get picked up by ICE and put in detainment. Now, there are some rules that say if you an absentia order is not an admissibility issue or something like that, it's criminal immigration stuff I don't do, like the U.S. doesn't accept it, but that's not going to stop you from being, detained by ICE and potentially be held in prison for a period of time until they figure it out and they release you. So there are efforts, and immigration attorneys are working on just undoing this Interpol Red Notice, because you can have countries that are political pariahs that do use this to get people that are dissidents too. So to stop this kind of nonsense and to use it more wisely. So I just want to give you notice that, you could have a client that has a perfect case. You go to an interview and all of a sudden there's ICE knocking on the door to pick them up. Now, another good thing that came out of Boston federal courts, it says federal judge orders sweeping changes to bond hearings in Boston Immigration Court. A federal judge ruled that it's unconstitutional for the federal government to place the burden of proof on undocumented immigrants in bond hearings. The decision from U.S. District Court Judge Patty Saris, God bless her, will usher in sweeping changes to the way bond hearings are administered in Boston Immigration Court. Saris has ruled that asking an undocumented immigrant who is eligible for bond to prove why they are neither a flight risk nor a threat to community violates the individual's due process. God bless. Due process, due process, due process. That's all we're asking for. If they fail it, if the burden's not there, which is on the state, then God deport them, whatever we're going to do. But due process is the key that protects our freedom. That's what makes this country different from all the frankly crappy countries in the world that walk all over people. Okay, so going to the last section, going to court. So U visa decision reviewable in court. Ninth Circuit says federal immigration authorities aren't immune from judicial second guessing when they deny U visas to criminal informants based on objective errors about their eligibility. A divided Ninth Circuit court ruled November 22nd. So that's that. Now, Supreme Court is going to have some big decisions to make. I mean, there's DACA stuff, but a really important one is they're going to make a decision on the idea of harboring illegal immigrants or giving them advice to avoid being caught by immigration. And this is going to be something that would destroy immigration law and immigration law practice as we see it. So it's kind of a crazy situation. There's this one agent that was these immigration agents that were like paralegals and notarios essentially, and they did something where they were caught for, I guess, ripping people off or something like that. And one of the reasons that they were arrested was for there's statute that says you can't like harbor immigrants or advising them what not to do to get caught, essentially as harboring too. And Ninth Circuit brushed that off, but it got appealed. It's going to Supreme Court. So it's very dangerous because as immigration attorneys, we have to tell the clients the whole law as it is. So, everything. So, but they're potentially making it so we can't advise our clients properly. So if that happens, that's a big issue that we got to make a ruckus about. Hopefully there'll be wiser decisions, and probably will, because it's a free speech issue on its own. So we'll see what happens with that. There's also a case, an Arizona activist who gave migrant humanitarian aid was acquitted in their second trial. I think this guy was putting out water for them, and they first put him in prison for that. But in the second trial, I think he was acquitted. The first one, I can't remember what happened, but the second trial was acquitted. It's kind of crazy. At the end of the day, if someone puts some water out there, that shouldn't be harboring or stuff. They should just let that happen. There's some humanity got to be left in here, but thankfully it was acquitted. And that's so important to have a jury trial of your peers for regular people to make a decision. I was talking to some guy, he's like hating the jury system. There's a lot of flaws in it, obviously, but at the end of the day, the jury system is for people to make a decision based on community standards. Now sometimes those standards suck because you might have a bunch of racists in the pile, but that's why in criminal court you have beyond a shadow of a doubt, you have to have 12 people make a decision. So hopefully if one of them does it and they stop it, they can stop it. Now guilty people will go free on that, but innocent people won't. That's the whole goal. We want to have community standards because sometimes our laws are too rigid or written, not to match what's going on in the community. Now, a really interesting case that came out about 237A1H waivers, 237A1H cases where you request a waiver for having issues at the time of admission. They find that out later after issuing the green card, and they want to revoke their green card and find you admissible. The Ninth Circuit said that in this, what was the case? So the case was, well, as a show host, I can't remember the case. I wrote this so long ago. But in essence, it was this. For 237A1H, the standard says that if a person, I think there's two fraudulent things. One, if there's misrepresentation or fraud, or if there was some issue with the perm or something like that, it's if they have a qualifying relative, they could get a waiver and just keep the green card as it is. But they have to be otherwise inadmissible. So if they had, criminal history or something like that, they're still inadmissible anyway, so they can't use the 237A1H waiver. But here, they were using they were inadmissible based on another factor. I remember, it was the J1 2-year requirement. And if you read the INA 212 inadmissibility on the J1 requirement, it says you could still be admissible for other statutes. So you could have, so let me back up for people not familiar with J1. So if you have a J1, sometimes there's a thing called a 2-year requirement, which if you got certain funding from a source, or if you're a medical student studying medicine in the U.S., or if you are part of a cultural exchange, or you're learning something in the U.S. and there's a skills list and you're learning one of those skills in the U.S., you have to go back to your home country for 2 years full, and you have to count the days before you could come back to the U.S. to get a green card, before you get an H-1B, before you get an L-1, or do change of status in the U.S. or something like that. You have to go do the home residency requirement, but you request a waiver. Well, in this case, the person didn't request a waiver, got the green card anyways. They found out later that the waiver was not approved, or they didn't have one, so they came to rescind it, and the court in the Ninth Circuit, with an interesting decision, said the 237A1H statute says that you have to be otherwise inadmissible. However, a person who didn't satisfy the J1 2-year requirement doesn't necessarily not satisfying, doesn't cut off them completely to be inadmissible. That just makes them not admissible on an L or an H. So otherwise, they are admissible. And the 237 amendment says otherwise admissible, or that means that that specific J1 does not create problems for admissibility or 237A1A. So that was a very interesting reading of the language, which makes total sense. So I thought that was interesting. I was going to make a separate YouTube video about it, but probably not. Okay. So next thing. Immigration judge says millions of records have gone missing. Millions of records of immigration court proceedings are garbled or have gone missing and may have been intentionally deleted, according to the union representing Justice Department judges who handled those cases. The union said researchers at Syracuse University who analyzed and published data from the immigration cases have found gross irregularities in records released by the administration of President Donald Trump. And as you know, the administration is trying to decertify the class for judges, their union, so decertify the union. So it's that's what's going on there. Now, one case, and this is a messed up case. So matter of Castillo Perez was a case where essentially BIA said that for cancellation or removal, if you have 2 or more DUIs or convictions for DUI, that's a bad moral character. You can't do that. And the way they made it sound was it's really going to apply for cancellation removal. But with that new memo that I didn't talk about earlier for NATs, they've put that standard on all good moral character kind of stuff. So it could be for adjustment of status, it could be for NATs. And the way they wrote it was like, you have to show you had good moral character at the time the DUI happened. So it's not like later on you got better. So for NATs, at least there's a 5-year period, whatever. But for adjustment of status, I'm not sure what the hell you're going to do for that. So these are part of the decisions that are coming in from the administration. Then there was a case of MAVNI versus Barr, 9th Circuit 2019. The panel held that the frivolous asylum application bar precluded an applicant from receiving all benefits under the INA. The court held that the phrase "this chapter," let's go to the details, but essentially, if you did a frivolous asylum, you can't get anything afterwards. You're done. Now, this I wanted to make a video on this too, but I'm not getting around to it. But I thought I'd just mention it here. The idea if you're a non-citizen having a firearm. So essentially, I think the rules say that if you're a green card holder, U.S. citizen, you can have a gun, but a non-citizen is not allowed to have a gun. But there was a U.S. Supreme Court case that ruled in favor of illegal immigrants in possession of a firearm. And I have all the laws here, and it was a complex case. I have to read it, so I'm like, why did I even put it here? Should have read this better. But it said if someone's here illegally or unlawfully in the U.S., except as provided for, like, someone has a non-immigrant visa, they can't have a gun. So in the non-immigrant visa category is like, if you're doing it O1 for a sharpshooter, they can have a gun. There's an exception for that. That's how the language works. And you could request special waivers for it too to have a weapon. But here, sorry guys, I can't. I'm looking at it, like, this is way too complicated to talk about. I could edit this out, but I just want you to mention that there's stuff. I wish I had the court case that it was under too. But here it is, 18 USC 922. They're reading the way the statute was written, from what I recall. And they played with the words and saying the statutes don't work together properly. So I think the fact pattern was this person that didn't have status or was a non-immigrant or something like that was going to the gun range and shooting. They found that they didn't have the mens rea and the knowledge to know that it was against the law or something. So they allow him to keep status or fix it up. And the fact that he had a gun was okay because of the way the statute was written. So I just wanted to say that heads up, because you might have cases where someone has a gun and what are you going to do? To say that there is a case that just came out on that. There's some stuff on that. In my notes on the next page, I break down the whole case. So it's Hamid Mohammed Ahmed Ali Raif. I guess it's Raifi, United States. It's a long name. And certiorari from the 11th Circuit. And they said that Federal Statute 18 U.S.C. 922, blah, blah, blah. But it goes into knowingly having firearms or not, a mens rea issue. So that was the last of my notes. I thought it was interesting. There's a couple of cases that saved about gun possession. I wanted to do a YouTube video because it pops up. One thing is I do these videos because it's interesting to me to see how the law works in these things. But then I get a bunch of people calling me that need that help. And I'm like, I don't do this area. I just like talking about immigration law. I don't like practicing it necessarily, especially if it's immigration or court-related kind of stuff. But it's fascinating. Immigration touches every aspect of life. So there's got to be a rule for every aspect. And many times it's missing or it's misapplied or this and that. And so it's like a puzzle. And when you have a puzzle-solving mind, like a lot of lawyers like us do, it becomes interesting. And so luckily I've made a practice for myself where I could, fund the lifestyle and then spend my free time just diving into stuff that's going to make me no money. But it's intellectually stimulating. I was watching an interview before this of this woman who wrote a book about brain dynamics and stuff, and it just talked about your brain constantly is making these like connections. The more older you get, the more you learn. The brain is like a muscle that's just like rebuilding itself and growing and making more connections, making you sharper. So it's constantly, you got to be reading. I got back into reading, so I'm reading at least 5 books a week. I'm sorry, a week, that'd be great. 5 books a month, and I'm actually posting on video on YouTube and LinkedIn for Immigration Lawyers Toolbox about what I'm reading and my recommendations. It's powerful, and there's so much information. Because you think writing a book is so much work. And for the most part, you're putting your name on there. So most books aren't garbage. Most of them, I can say there's something in there that's worthwhile. Because, you got to fill out those pages and you start letting stuff out. Because sometimes you're worried, like, these people are going to really give good information out. But there's going to be some in there. So it's worth digging in there, getting information about business, about life. That'll be something that'll help you, make you better. And the more you do it, it's just like buying upgrades. It's like those video games where you're walking around, all of a sudden you see like a box that has a red cross on it. It's like it's a 1-up or something, or it's ammunition you pick up there. These books do that. It's time consuming. You got to be a reader. But even if you're not a reader, you should put that aside. I mean, if you're a lawyer, you read a lot. But I know it burns your head because you're reading stuff constantly and writing. But, pick up a book, have a couple around at all times. Just keep ordering on Amazon, whatever the price is. Have them delivered to your house. Have them everywhere. Constantly keep reading. It's just, it's good for your health. I probably should be exercising more too. Maybe less reading, more exercising, which I'm not. But also it really ups the information. Again, there you gain so much, and it helps you become more successful. So that's something I definitely recommend. If I can end with that. All right, so hope you enjoyed this one. Almost hitting the hour mark, but not so much. I want to thank again all the people who listen and contact me in the community we have. There's neat stuff coming. I'm going to keep growing this situation, but this toolbox, the podcast, everything. But I know there's a lot of you out there that reach out, and there's a really good direct connection we have, which is really satisfying. It really takes life to the next level, knowing that you all are out there. Other than that, if you're on iTunes, please write a review. It'd be great, much appreciated. Follow on it on YouTube, on LinkedIn, subscribe, follow. There's always more information that I post on LinkedIn, on YouTube. And really use LinkedIn. It's a great resource. Get into it. There's a lot of spam there, but the more real people come on board, and there's a lot of people there already. There's a lot of business going on, a lot of ways of connecting, a lot of ways of sharing information. It's a very flexible format there. So I've gotten really into LinkedIn recently, last couple months. And so I want to do that. Other than that, the email is info@immigrationlawyerstoolbox.com. The podcast is part of the Toolbox program. If you're interested in learning about the premium version of the podcast, I guess, the Immigration Lawyers Toolbox, the daily tips, other information, just email me. And if you're interested in learning the marketing system that I have, as well as getting into immigration law, how adjustment works, how a marriage case works, and I'm going to be doing an L1 scenario for that too, and really getting some hardcore information to you, just email me at info@immigrationlawyerstoolbox.com, and we can set something up, have an initial call to fill you in on what you need, and if I got what you need. So until next one, have a good one.